clear. Today, it seems like the Republicans have not really fought very much about whether or not Trump was guilty or not. In fact, their fight seems to be over whether or not you were authorized to prove their guilt. Do you recall a number of Republican members asking about whether or not your appointment was okay, even though we know that you've testified about the more than 100-year precedent that allowed for your appointment?
I was asked questions about that today, and our position, as we filed in our appeal, is that there was strong support for my appointment, including Supreme Court precedent directly on point.
Thank you so much. Additionally, everybody's been all gingerly here today, but I don't know why we're acting surprised that a man who had close to 90 allegations out of 4 different jurisdictions and ultimately ended up with 34 convictions after a jury was able to hear all the evidence would possibly be committing a criminal act on January 6th. In fact, considering the fact that we are now under the impression that he is violating people's due process rights, he is ignoring court orders, he's starting wars without congressional authority in contradiction to the Constitution. He's enriching himself to the tune of over $1.4 billion. He's shaking down electeds to draw maps that will help him stay in power because the Republicans don't understand that they swore an oath to the Constitution and that we are supposed to do checks and balances. He's also shaking down TV stations to get money. So why are we trying to pretend as if it is out of the realm for this particular man to commit the crime that he committed on January 6th, and frankly, the only reason he ran for president was to make sure that he would not be prosecuted, because I fully believe that you would have put him under the jail based on our long-form conversation that we had. But according to your special counsel report on page 137, it states the department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution. And that, quote, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. In other words, Donald Trump ran for president, like I said, so he wouldn't have to spend the rest of his life in prison. The chairman and other members of this committee have spent all day attacking you and trying to rewrite the history of January 6th. But Mr. Jim Jordan, the chairman, failed to mention how he was running around the Capitol terrified by the possibility that all those insurrectionists would harm him. In fact, on page 97 of the deposition transcript, you mentioned how Mark Meadows, the president's chief of staff, quote unquote, never saw Jim Jordan so scared. The chairman also failed to mention that he was in direct contact with the White House in the days leading up to and on January 6th, which is why his toll records were subpoenaed by your office. Let me be clear, because they're trying to act like this is Democrats on Republicans, and I guess you are a covert Democrat that knew that he was going to try to steal an election before he tried to steal that election, and so therefore you were somehow put into place. I mean, the conspiracy theories make your head spin, but nevertheless, were you going to subpoena the toll records of every single Republican simply because they were a Republican?
No, we subpoenaed the toll records in the course of this investigation because they were relevant to our investigation.
Relevant? Oh, okay. All right, so that means something about facts. So let's talk about facts. Donald Trump lost to Joe Biden, yes or no?
That's correct.
Okay. In fact, 60 federal and state courts have found that there was no evidence of election fraud. Trump's own attorney general and vice president knew that he lost the election, but he still tried to steal the election by pressuring state officials, designing fake elector plans, nearly having Mike Pence hanged, and ultimately demanding that his supporters, quote, fight like hell, correct?
Correct.
We all saw it happen we all saw what happened once they reached the U.S. Capitol. As your report outlines, President Trump knew that he would incite violence at the Capitol that day. In fact, some of Trump's senior advisors were pushing for violence. For example, page 81 of the report details how co-conspirators number 2, John Eastman, tried to convince Mike Pence to break the law, stating that, quote, violence was necessary. So it isn't just Trump who is responsible for the death of multiple law enforcement officers and the injuries of thousands of people. A lot of Republican members of Congress are also responsible. 147 Republicans voted to overturn the 2020 election results, including multiple members currently serving on this committee. And I will yield.
Gentlelady yields. Gentleman from North Carolina is recognized.
We've got a slightly different setup for you today.
Yeah, right here on the desk.
Exactly. Instead of just running through headlines, we have a stack of primary source documents. We are looking at a recent congressional hearing transcript featuring Representative Jasmine Crockett, and we are cross-referencing that directly with the special counsel's report on the January 6th investigation.
It's a really fascinating exercise in source analysis.
Yeah.
Usually these hearings are just, soundbite generators.
Right.
But this specific exchange is basically a roadmap to the actual underlying evidence.
Which is exactly our mission today. We want to unpack this fundamental clash. We have Republicans focusing on the legal authority of the investigation and Democrats focusing on the evidentiary findings.
Exactly. The procedure versus the substance.
Right. So let's start with that first half. What was the procedure argument being made there?
Well, before Crockett even starts her line of questioning, she notes that the Republican members used their time to challenge the actual authorization of the investigation. Basically, they're arguing about the appointments clause of the Constitution.
Wondering if the Attorney General actually has the statutory authority to appoint a special counsel with that kind of independence.
Right, which isn't just a stall tactic. It challenges the entire legitimacy of the process. But the witness, the special counsel, he pushes back hard on this.
He points to over 100 years of Department of Justice precedent, right?
Yeah, precedent and Supreme Court rulings upholding similar structures. So the defense is basically saying the referee shouldn't be on the field, and the referee is pointing to the rule book that put him there.
And that is right where Representative Crockett pivots. She moves away from who is asking the questions and digs into what the investigation actually found about the former president's intent. She posits his motivation for running for office is basically to avoid prosecution.
She anchors that claim to page 137 of the special counsel's report. That page is crucial because it references the Office of Legal Counsel's long-standing opinion that a sitting president just cannot be prosecuted.
Complete categorical immunity while in office.
Exactly.
But there's a massive caveat in the text. The report explicitly says the admissible evidence was sufficient to obtain and sustain a conviction.
Meaning the only real barrier to a guilty verdict was his potential return to the presidency.
Right. The but-for argument. A legally sound case ready for trial, but it's a checkmate situation because of the political office. It implies the presidency itself is being used as a legal shield.
And she doesn't stop there. She turns the focus to the committee room itself, specifically to Chairman Jim Jordan. It's very meta, right? Investigating the investigator.
She draws a sharp contrast. Jim Jordan is aggressively attacking the investigation now, but she pulls up page 97 of the deposition transcript to highlight his behavior on January 6th.
Right, that's Mark Meadows, the former chief of staff, testifying.
Yeah, and Meadows states on the record that he never saw Jim Jordan so scared as he was by the rioters that day.
It's a complex picture. A congressman terrified by the violence, who is now leading the effort to challenge the investigation into that same violence. Crockett connects this fear to the subpoena of Jordan's toll records.
Because the Republican argument was that subpoenaing a member of Congress was just a partisan attack.
But the special counsel clarifies it wasn't about party affiliation. Jordan was in direct contact with the White House during the insurrection.
Which makes the call logs factually relevant evidence. The standard investigative procedure, not a political hit job.
Exactly. And speaking of the insurrection, that leads us to the final citation about the intent behind the violence. The defense often claims the riot was spontaneous or people genuinely believe the election was stolen.
But Crockett notes that 60 courts found no fraud. And then she drops a major quote from page 81 of the report. This is from co-conspirator number 2, identified as John Eastman.
That's the conversation with Mike Pence. Eastman allegedly told the vice president that violence was necessary.
Violence was necessary. That phrase changes the narrative completely.
It implies calculation. The chaos wasn't an accident. It was a tool to achieve a political goal, specifically delaying the certification.
And Crockett points out that 147 Republicans voted to overturn the results even after that violence happened.
So you have this huge tension, a debate about procedural validity on one side and documented testimony of fear, direct White House contact, and a belief that violence was required on the other.
Procedure versus substance. These citations force you to really look at the hard evidence. We're keeping things objective here, just looking at what the primary sources say, but it definitely leaves you with a heavy question.
It really does. Does the office serve the law, or does it insulate you from it?
The report concludes the evidence was sufficient for conviction, but for the presidency. So here's something for you to mull over that we haven't touched on yet. If holding public office essentially functions as a literal shield against existing criminal charges, how does that shift the fundamental nature of political campaigning? Does running for office stop being about public service and start becoming a necessary survival tactic for avoiding prison?
It makes you wonder how that changes the caliber and motivations of the people appearing on your ballot.
Definitely something to think about. Thanks for joining us for this Deep Dive.